name's Amy Borror. I'm the legislative liaison for the Office of the Ohio Public Defender. Just about a month ago, the Ohio Supreme Court issued a decision in a case called State v. Williams. And in that case, the Ohio Supreme Court said that the SORNA registration requirements that Ohio implemented in its Senate Bill 10 are punitive. And that was a very important ruling because in the past, the Ohio Supreme Court and other state Supreme Courts and the U.S. Supreme Court had said that the registration requirements were not punishment, that they were just an administrative function, similar to having to renew your driver's license. And now that the Ohio Supreme Court has said that the new Ohio law is punishment, what that means is that it cannot be applied retroactively. It can't be applied to people who committed their offense before the new law went into effect. So in Ohio, the result has been that now nobody can be classified under Ohio's SORNA law if they committed their offense before that law went into effect. We're hoping that that decision from the Ohio Supreme Court might have some influence in other states. There are lots of other courts that are looking at this same issue to see whether the new requirements that come in under the Adam Walsh Act and SORNA cross the line into being punishment. And if it is punishment, then that really restricts who it can apply to and how it can be applied.
So you referred to the U.S. Supreme Court. Obviously, in the past, they've said that registration requirements are not punitive. What's made the difference? What's taken us over the top with this thing?
The Ohio Supreme Court actually didn't break it down point by point. They said that there wasn't just one thing or a list of certain things that they could point to that said, you know, anything up to this point would not be punishment and anything past it would. They said that what they had to do was they decided that Senate Bill 10 was distinct and different from the Megan's Law that preceded it. And when they looked at Senate Bill 10 in its entirety, that it was clear to the court that it had moved into punishment versus just the administrative regulatory function.
All right, but working in this stuff every day, why would you, from a legal perspective, from your legal knowledge, believe that the registry has taken a turn toward punishment, or why should it be considered punishment?
I think there are a lot of different reasons. One big change in Ohio is that we went from a risk-based system to an offense-based system. When you were looking at a risk-based system, I think you could make the argument that it was maybe more administrative or regulatory because you were treating people differently based not on what offense they had committed, but based on what risk they posed in the future. When you switch, though, to just a pure offense-based registry, you're tying somebody's future requirements only to the offense that they've already been convicted of. And when you tie some sort of requirement to a conviction, that is traditionally what we think of as punishment. So I think that was a big factor in Ohio. Other things that I think played into the decision and that might affect other courts would be the length of the requirements. The majority of people under the SORNA scheme end up in Tier 3, which is a lifetime requirement. It's a lot of in-person verification, at least 4 times a year. It's a lot of information that you have to hand over when you go and register. It used to just be, you know, name, address, just some very basic information, and now we're talking about cars and license plates and where you work and where you go to school, and you're having to really turn over a lot more personal information, and I think that all of those factors combined tend to lead the courts to think that maybe this has moved into punishment.
Mm-hmm. Well, generally when we hear the media or parents or general public speaking, they're concerned obviously about their children's safety. How does a child's safety play into this risk-based assessment as opposed to kind of operation of the law assessment?
Certainly when you're talking about public safety and you're talking about the supposed function of these registries, the supposed purpose is to keep people safe from future crimes that might occur. And I think there's debate about whether these registries, even in their best form, could offer that protection. But if that's your true purpose in creating and maintaining these registries, it makes more sense to do it on a risk-based scheme, where you focus the attention of the registry on people who pose some risk to reoffend. rather than flooding the registry with people who pose very little, if any, risk to reoffend. Now, all of that I've just said is assuming that these registries actually offer some sort of public safety protection, and I think there's a lot of argument that they don't. And like you said, the kind of battle cry about these registries is protecting children. If we're going to talk about protecting children, in some ways it's a completely different conversation than we would have about the registries, because children are most likely to be offended on by family members and acquaintances. I think it's 97% of children are offended on by people that they know. And the vast majority of people who commit offenses are committing them for the first time, or at least being caught for the first time. So they're not people who are already on a registry. So in some ways, this issue of public safety and protecting children is almost a very distinct issue than the registry and the legal issues that we're talking about.
So what would be the best approach in your opinion, for a legislator or a parent even to take in protecting their children from people that they feel might be dangerous?
I think probably the best approach for parents and for legislators is to educate themselves, find out what research tells us about who is most likely to offend against children, not assume that it's the boogeyman, that it's the person who pops out of the bushes. I think the more that they educate themselves about who actually poses the risk, the more likely they are going to be able to actually protect their children. Chances are it's not going to be a stranger walking down the street. Chances are it's going to be a daycare provider, a babysitter, a relative. And the more that people are armed with the facts, the more that they can actually use that information to protect their children.
Can you speak a little bit? You showed a chart in your presentation about the how the Megan's Law versus the Senate Bill 10 affected the registry. Can you talk a little bit about that?
Sure. Under Ohio's old law, it's Megan's Law, when we had the risk-based registry, about 3/4 of the people on our registry were in our lowest tier, and those were people who were found not likely to reoffend. I think it was about 18% of the people that were classified in our highest tier, and those were people who, after a court hearing, a judge had determined they were likely to commit another offense. If you look at the research that's out there about recidivism and about people who actually do commit future sex offenses, those numbers match up fairly well. It's not exact, but most of the research out there, I think, shows you somewhere in maybe like the 8 to 12 or 18 or 8 to 15% recidivism rate, much lower than most people think it is. People generally think it's 50%, 75%, 100%, but we're talking, single digits to low teens as far as how the actual rate of recidivism. That's what our old risk-based registry looked like. It was very bottom heavy, not very top heavy. Do you need me to hold on?
Okay, so continuing with your comparison of the old registry.
So the old registry was bottom heavy, which made sense because most of the people are not likely to reoffend. When we reclassified everybody under Senate Bill 10, the registry flipped upside down and became very top heavy. More than half of the people on the registry were put into Tier 3, which is supposedly the more serious offenders. Another third of the people ended up in Tier 2, and just a very small number, I think 13%, ended up in Tier 1. And so it made the registry look like most people pose a threat to reoffend, which we know is not the case. What I think that does is it dilutes the effectiveness of the registry. If the registry has any hope of being a tool that could improve public safety, it really needs to be divided in such a way that it shows people who look at the registry who may actually pose some threat. Our old registry, our risk-based registry, I think had some chance of providing that. The new one, the Senate Bill 10 one, really has no chance of providing that information. It's still, I think, kind of an open question about what it takes for a state to comply with SORNA. Originally, the original SMART office, 3 years ago now, really seemed to demand that states strictly comply and follow every letter of SORNA, dot every I, cross every T. And because of that, no states came into compliance under that original SMART office. No state, no jurisdiction met all of those standards. Under the new administration, under the current administration, they seem to have backed down from that strict requirement some. They don't require absolutely every letter of the law to be followed. And that has allowed more states and more tribes to come into compliance. But it also kind of leaves some questions open. States don't know exactly what they do need to do in order to comply. In some ways, I think it's good because it doesn't demand that states do lots of things that states don't want to do, but it also makes it much more uncertain. If states maybe do want to comply, I think that they don't necessarily know how to do so. And so that complicates the matter some. We have 14 states in compliance now, a total of 24 jurisdictions, which is a very small number of the total jurisdictions that have to come into compliance. We might have a few more show up in the next few months as the SMART office reviews the applications that they've gotten. But I think what the law has become is not what it intended. The purpose behind the federal Adam Walsh Act was to create essentially one scheme, a national registry that was the same no matter where you went in the country. But because the states that are coming into compliance are more and more different from each other, I think it's clear that there's not going to be one seamless registry and that there still are going to be a lot of differences state to state.
So how much how much money are these states saving by complying with SORNA?
I don't think states are saving anything by complying. I think, in fact, they're spending quite a bit of money trying to comply. And what we've gone through in order to try to comply is we reclassified 26,000 people. So it was whatever staff it took to sit down with those records of 26,000 people, determine what classification they should go into, send them notification of their classifications. It was more than 7,000 legal challenges to those reclassifications that went into our county court system. And with each one of those petitions, you have the court personnel, the judges, the prosecutors, the defenders, dealing with each of those challenge petitions. More than 150 of those challenge petitions were appealed. And again, with each of those appeals, you have the appellate court staff, prosecutors, defenders, and then dozens of the cases work their way up to our state Supreme Court. So legal challenges alone, I would say, easily cost the system in excess of $10 million, and we've risked losing maybe about less than 1.5.
$10 million as opposed to 1.5.
Right.
For compliance.
Right.
Cost effective?
I would say no.